Hello, everyone. Welcome. Let's refresh our YouTube so we can catch up. This is not my live stream tonight. This is a live stream of Lori Hellis. You all know her. We've talked about her a lot. I am hosting this on behalf of the Doomsday Justice for JJ and Tylee Facebook group. There's a link in the description. If you'd like to join them, you can apply to join. So I'm going to be watching chat, funneling questions, but I'm going to turn the floor over to Lori Hellis. So here we go. Welcome. I'm so happy to get to talk to you.
Hi, it's great to be here.
Oh, so there's a lot going on.
A lot going on.
We need you. We need you. All right, I'm going to keep an eye on chat, but can you give us just a basic synopsis of what the heck has happened the last week?
Wow. Well, in the last couple weeks, we've had a couple of hearings, and those hearings have been, for the most part, behind closed doors, which makes everyone uncomfortable and makes everybody curious about what's going on. Oftentimes that's because, well, in this case, it's because there's so much publicity and everyone is concerned about making sure that there's an opportunity for a fair, unbiased jury pool. And the more publicity goes out, the harder it is to get an unbiased jury pool. So what we know at this point is that they went behind closed doors. The judge called all the lawyers and the court reporter in. They put something on the record, which they then sealed. And then we heard that we had these two ex parte motions that came up, and they're also sealed. So we don't know who filed them. We don't know the subject of the filing. So we're all kind of sitting around trying to read the tea leaves and figure out what happened in those closed conferences. As a lawyer, I understand the importance and the need to have those hearings remain private. But as a citizen, we want to know what's going on. So I think reading the tea leaves, we can surmise, thanks to some sleuths who've taken a look at the formats of the filings, that they were filed by Rob Wood. The reason I say that is because DA's offices use a database, and they use templates in that database to produce all of their filings for the court. So all their filings look the same. So what's going to happen is when you're looking at all those filings, the headings are all going to be the same, the formats are all going to be the same, and it's pretty easy to figure out that the filings came from the DA's office that way. The other thing is how simultaneously they were filed, because in the court's e-file system, in their electronic filing system, you pull up a window, you put in all of the information, and you press send, and it files that document. You pull up the next window and do the next case. And it seems to me that that's what happened. Rob Wood's assistant pulled up Chad's case, filed the document, hit file, pulled up Lori's case, filed the document, hit file. Because we haven't seen those kind of simultaneous filings in between the defense attorneys. I'm not sure they're that coordinated. So seeing two filings that happen within a few minutes of one another, that would be kind of unusual. More typical if they're coming out of the same office, and that would be the DA's office.
So that makes a ton of sense. It really does. And unfortunately, we are all guessing at this point, which is really frustrating. But we have some good questions coming up in chat. First, from Jenny Stern. She'd like to know, why do you think it is taking so long for charges to drop? Why do you think Rob Wood could be waiting upon test results of evidence or grand jury, slow wheels of justice? What do you think about that?
Well, all of the above. First of all, COVID has put a huge damper on grand juries and on people getting in and out of the courthouse. So my understanding in Rexburg is they're still not holding grand juries. I don't think that they're a small jurisdiction. I don't think that they've come up with a way to have grand juries remotely. So they're really waiting for grand juries to be able to come back and be in person. So I think that's part of it. Part of it is that I think Rob Wood was waiting for the autopsies for the children, which I've heard rumors are back. I don't know how substantiated those are. But I looking at the statutes in Idaho, I think that one of the reasons Rob Wood is waiting is because we all know the condition of Tylee's remains, and that may impact how charges are filed. Sometimes, for lack of a better word, really horrendous behavior on the part of a defendant and in dismembering a body could be the basis and grounds for the death penalty. So I think those are some of the reasons why he's kind of holding off.
Now, a question about the grand jury. Because we saw them use a preliminary hearing for Chad, do you think Rob Wood would pursue charges through a grand jury or have another preliminary hearing style thing?
Oh, good question. Well, it's very difficult to get either one of those things to happen because of COVID and the restrictions on the court from COVID. I think we're going to see those ease up in the next month or so as more people get vaccinated and things start to open up a bit. But I think would be difficult either way. And I suspect that he would rather have a grand jury because it's a less public forum. Less likelihood of having to share some information that then later could taint a jury pool. So
yeah, definitely. We got a lot of information from Chad's preliminary hearing, so I could see him wanting a different tack for that, for sure.
Yeah, and I in other jurisdictions, preliminary hearings are pretty uncommon. I understand they use them a little bit more often in Idaho than in other places, but they're pretty uncommon just for that reason, because you really do sort of play your hand early, and sometimes you want to
Hold back a bit.
Yeah. I mean, preliminary hearings are good in one respect because they do kind of cement the testimony. When you get somebody in and they're on the stand and they're giving sworn testimony, that's pretty much carved in stone. So it's easy to then go back and say, yes, but didn't you say at the preliminary hearing, didn't you testify under oath to X? So it has its benefits, but for a really complex case like this, I would suspect that they would prefer a grand jury.
Now, the next question, also from Jenny Stern. Do you agree that the take that if there were charges coming, they should be coming soon, or else the prosecution is playing games by keeping them behind bars this long without charges?
Well, they have been charged. They're behind bars on the current charges, on the current destruction and concealing of evidence and the conspiracy charges. So there are charges pending. It's not as if they're being held without charge, which is which is something our system is very opposed to. So they have been charged. The question is how long and what's going to happen. Yeah, I think COVID has slowed things down. I don't think that Rob Wood is in a big hurry because he doesn't have to be. Right. He's got them in custody on these charges. Trial dates are set. They've waived their speedy trial rights. Trial days are set. So he doesn't have to rush to the new charges. And it's important to remember that prosecutors are very methodical because they know they're only going to get one shot at this. Mm-hmm. They don't want to run into the situation of they try this case right away and then new information comes up that should have been brought to the forefront at trial, and now they're stuck with whatever the verdict was to begin with. So if somebody's found not guilty, they can't be retried.
Right. Isn't it true that most forms of appeals have to have some basis in new evidence?
Well, either that or some sort of error in the way the trial was
Right.
conducted. Yeah.
And
So it can be because there's error in the way the trial was conducted. That means that the outcome would have been different had the court not made that error, or because there's new evidence. Yeah.
the next question, a little off topic, from Andy Ryan. Hi, Andy. How you doing? Will your book go over the strategies and happenings in the trial from your perspective as a lawyer?
Oh, absolutely. I mean, one of the things that I really am fascinated with is sort of understanding the thought process for all three lawyers, not just for the prosecution, but, for everybody. So probably a little bit more of that than you might get from your average true crime writer, because that's sort of my expertise. So yeah, we'll definitely be covering that.
I can't wait for that. I really can't. Next, again from Jenny Stern. I'm wondering if they found any evidence in Tylee's bone marrow, and really hoping that the duct tape and garbage bags found on JJ are covered in DNA, fingerprints, and fibers.
Yeah, we just don't know. There's a part of me that really wants this case over so that I can delve into those things and really start digging around to find out what really happened. And I think those things are going to have to wait at least until there's a trial, or until there's a plea and we can get a hold of all of that information. So yeah, I can't wait till I can request all the court files and request all of the DA's files and go interview people, and yeah.
Yeah, and that may have to wait till even the trial's over, at least for release of some discovery, if they ever release it. Like the children's autopsies might be sealed in perpetuity, I would guess.
I don't know. I don't know whether it would. It depends on the court, really. If they were to go to the court and say, we want these documents sealed permanently, I don't know. Most courts are hesitant to seal things indefinitely.
Good, because I think we're going to need those answers. We have certain cases like the Chris Watts case where he didn't go to trial. He pleaded, right, and we didn't get to see stuff, but they eventually released everything except for the children's autopsies. And right, that's fine. I don't want to see that. I really don't. But in some cases, you never get those answers until you get to see those documents.
Right. So, and often with autopsies, the narrative report is enough. Mm-hmm. We don't need all of the really awful details, but sometimes just getting the narrative report from the autopsy doctor is enough.
Right. The next question from Jess Nelson, mistrial. Do you think they will go for the death penalty? This is what we all want to know.
It's kind of interesting. The death penalty is often a tactical. It's really sort of calculated into the tactics of the case, and it's a real. It depends a lot on the DA. What I'll say is Idaho is not huge on the death penalty. I mean, there are only 7 people in death row right now in Idaho, and they don't have a really. There's some states like Texas. Where they're pretty aggressive about their execution schedules and about pursuing executions. Arizona is the same way. So there's 119 people on Arizona's death row, and the last execution was in 2017. So my thought as a former prosecutor and a former defense attorney both is to use the death penalty as leverage. Every DA wants certainty, and you don't get certainty, especially in a death penalty in a murder case, out of a trial, because you end up having multiple appeals and years of going back. I mean, there was a murder trial in the jurisdiction where I practiced that had come back on appeals 25 years later. So, I mean, it is an endless battle.
Right.
And DAs would much rather have the certainty of saying, okay, I'll take the death penalty off the table if you'll plead and you give me a confession and all of the information about what happened, and you'll come clean.
Right.
Because that's certainly a more final resolution to the case. So sometimes, often, attorneys are much more likely to use the death penalty as a bargaining chip.
Yeah. One of the concerns I was thinking about with the death penalty, given that this area is a very religious area, there have been studies done of how difficult it is for a jury to come to a death penalty ruling, to decide on the death penalty, because they have that trauma of thinking, I just sentenced somebody to death. Right. So given that the jury is likely to be a highly religious group of people, that to me could be even a little bit risky.
Oh, I think so. Because I think you never know how people in that community feel about the death penalty. I mean, there are people who are very religious and who are very concrete, black and white. The Bible says,
right.
Eye for an eye.
Eye for an eye, yeah.
But there are an awful lot of people who really feel that the death penalty is inequitably applied and have some real reservations about it. So, I mean, that's a difficult question for jury selection, and judges allow attorneys a fair amount of leeway and voir dire because of those difficult questions. But nonetheless, you have a finite amount of time to have conversations with juries, with potential jurors about those things. And, sometimes it's hard to suss those things out.
Mm-hmm. Now in Idaho, I think this is different for all states. If the jury finds them guilty and it's a death penalty case, the death penalty will come into play in sentencing. Is that something the judge goes with, or just the guilty plea means death penalty, period? Or does the jury get to decide the penalty after the guilty verdict?
So generally there's a penalty phase. So there's a phase of the trial where guilt or innocence is determined. And if the jury comes back with a guilty verdict, then the penalty phase comes into play. And that's when you get people doing mitigation studies and you get psychological evaluations and digging into the person's childhood, and because a lot of the questions in a death penalty phase have to do with whether or not you think this person could ever be rehabilitated, or if this person is going to consistently be a danger to them, to the public.
Mm-hmm. Now, in Idaho, there's no technical insanity defense for the guilt or innocence portion, but can't they introduce, like you said, the psychological study and some sort of insanity, but kind of an insanity defense in the penalty phase, even though it's not technically part of the Idaho guilt phase thing?
Sure. In the penalty phase, what you're doing is you're asking, is the punishment for this person's actions appropriately, is that punishment death? And the question is whether or not that person, there are things in that person's background that warrant some sort of mercy. And certainly if you have somebody who's pretty severely mentally ill, not meeting, even in states that allow the insanity defense, not meeting the standards, because that's pretty narrow standard. Mm-hmm. Where that you would try and remediate the death penalty by saying there are reasons why this person couldn't control their actions or did something unexpected or against their character.
Right. So we could see that in this case. I would not be surprised. Kathy Lawrence asks, can they move forward with Lori's misdemeanor charges in Madison County and have that done?
Well, they could. I don't know that they want to. I don't know that it would make any difference one way or the other. I frankly think those charges are going to get dropped. They're just going to go away.
They seem small potatoes compared to everything else.
Oh, absolutely. Absolutely. And, you know, at this point, she's been in jail long enough that if she were to plead to those, she'd probably get time served. So,
True.
you know.
She's been in jail for a little over a year now.
Right.
Yeah. Jess asks, do you think this trial will go down in history books as bigger than OJ or Jodi Arias?
Only for the people who are involved in it. I think it's going to be a very notorious trial, and I think people are going to have a lot of interest in it. And certainly it is as interesting. There were some things that went into particularly the OJ trial that were very different. One of the things was it was really one of the first trials that was televised live.
Right, and he was famous. Everybody knew OJ, so that helped a bit.
Right. So, yeah, I don't know that it'll be that big. Jodi Arias, maybe, you know, maybe.
Carrie Ann wants to know, can they come back later and file charges on Melanie Gibb if she was found to be involved somehow? I want the answer to that question myself.
As long as it's within the statute of limitations, yeah.
Oh, how long is that? Hopefully not, 6 months.
It depends on the charge and depends on the state. Okay. But usually 3 to 5 years for most crimes.
So there's hope. We can be hopeful.
Some major felonies, it's up to 10 years. And then, of course, murder generally doesn't have a statute of limitations.
All right. LPTX says, JJ's autopsy is not as complicated as Tylee's. I get that. But they have to have both in order to move on with the murder charges. Wood gets one shot to get a conviction, one trial. That's technically a statement, but I agree with that. What do you think?
Yeah, I think so. And I think he strikes me. And first of all, I have to say, I don't know any of these people. I've never met any of the lawyers. I don't know any of them. So, my impression is the same as yours. He strikes me as a very methodical, very even-handed kind of a guy. And I think that he is going to approach the case that way. And I think that means making sure that he can present the most cogent, comprehensive case. And I think, so certainly I think he will want to have all that information on both children because that'll be one case.
Right. Diana Simmons asks, Lori, what do you think Zulema has that would allow her immunity?
Well, I've speculated that she has something, some kind of information about whatever was used to kill Tammy and to kill Alex. And I think she has some kind of information about that. And I certainly think that she knows a lot about what Alex was doing, his movements, where he was, his motivation. I think she has a lot of information about those things, yeah.
That'll be interesting to find out. Jenny Stern asks, I heard a rumor that Summer Shiflett dropped her lawyer after he gave the tape to Means and Pryor in order to get Rob Wood off the case. Any truth in that?
No idea. I wouldn't blame her.
Yeah.
I mean, let's remember that this same guy was involved in the horrendously libelous statements that were made about Brandon Boudreaux, and his malpractice carrier has now shelled out $12 million to Brandon Boudreaux because of his behavior. So, he's burned as a witness in this case.
Mm-hmm. And that would be Garrett Smith that we're talking about.
Right.
It's problematic. Jess Nelson asks, have you seen a death penalty case all the way through to execution in your career? That's a good question.
Oh, that is a good question. I have not seen one go all the way to execution. There are a couple in Oregon that are sort of circling potential execution, but my state where I practiced in Oregon, there's a moratorium on death penalty, on executions right now. So they're still seeking the death penalty. Prosecutors are still prosecuting the death penalty, but the governor put a moratorium on, I want to say it's been about 8 years ago. Yeah.
Denise asks, why would they kill and dispose of Tylee so horrific? I don't understand. Do you think Lori helped with that, or just Chad and Alex? Why so brutal?
Well, there's a lot of theories about that. A lot of theories about her disposal being much more emotional, and the difference in the way that the children's bodies were treated sort of being a reflection of how Lori or the other people felt about both of them. I don't know. I think that's a really perplexing question. I mean, it's hard to speculate. You could think, well, they used that really difficult, complicated, labor-intensive kind of a means to get rid of Tylee's body, not realizing how, maybe underestimating how hard it was going to be to do all that, both emotionally and just the logistics and the sheer physical, how do you do that?
Mm-hmm.
And maybe when it came time to dispose of JJ's body, they thought, oh, I don't want to do that again. Let's do something a little bit more
Less gruesome, yeah.
less difficult logistically. So, I mean, I don't know. It could be something that simple, or it could be that we could draw some conclusions about how the people felt about the kids.
Mm-hmm. Jenny Stern with another brilliant question. This is something that you and I talked about. If Lori's found guilty but mentally impaired due to her religious beliefs or other factors, could she get sentenced to time in a mental health care facility before or instead of going to prison?
Oh, good question. So because Idaho does not recognize an insanity defense, so there's two different pieces to this. One is competency to stand trial. And a person has to be competent to stand trial. They have to be able to aid and assist their lawyer, and they have to understand the process and what is being placed in front of them, the decisions that they need to make, like do you testify or not, those sorts of really fundamental decisions that defendants make. And that goes to whether or not the person is competent. Sometimes people are so mentally ill that they're not competent to stand trial. That's a different piece. But if they're deemed to be competent, they understand what day it is and what the prosecutor's job is and what their defense attorney's job is and what their rights are. Then we look at whether or not mental health can be used as a defense. And in Idaho, it cannot be used as a defense. The only way that you get to the mental health of the defendant is by claiming that the person was so mentally ill that they didn't have the ability to understand what they were doing was a crime. So they're so mentally ill that they're not competent. And that's certainly not the case here.
Right.
In a case where you have someone whose competency is questionable, in some states, they would put that person in a mental institution and try and restore them to competency so that they could be tried. But that's not Idaho. Idaho doesn't do that. So I don't think there's any chance Lori's going to end up in a mental institution rather than a prison. Because that's not the way that Idaho law functions.
Right. And very similar to another case we saw, the Timothy Jones Jr. case, he murdered his children and was trying to claim insanity. That was actually his defense. But the fact that he had made a list of what to do after the murders, how to escape, how to bury the bodies, like very methodical. All of this stuff shows he clearly knew what he did was wrong and was trying to hide it and evade it and manipulate. So it didn't work. It just didn't work. So that's a very high bar to prove, I think.
Oh, yeah. Very high.
Chelsea Diaz. Hi, Chelsea. She asked, I thought Lori's misdemeanor charges in Madison County were dropped already.
They were not. One of the charges was dropped. So when Lori was originally arrested in Hawaii and extradited back to Idaho, she was charged with abandoning her children. And she was also charged with conspiracy to lie to police. I can't remember what Idaho phrases the actual charge, but essentially she was charged with getting Melanie Gibb to lie about JJ's whereabouts. So those charges, the charges having to do with soliciting false information to a police officer, are still pending. Now they're both misdemeanors. The child abandonment charges were felonies, but the remaining charges are misdemeanors.
Yeah, and there is still movement in that case, not much, but as soon as that happens, we'll be able to see it and tell you about it. So we're keeping our eye on Madison County too. Now, Jenny Stern, again, with the awesome question. Could Lori be charged for using Charles's credit card, Amazon account, Tylee's bank card, Social Security fraud, all of that? Could these be federal charges, and would they be added to this case?
They could. The question is, oh, sorry, you can hear my dogs barking. The question is whether the federal government would take the time and the trouble and the expense to prosecute them. My guess would be probably not. The issue of the credit card, I think there's a gray area there, because I think she would say, well, he gave me permission before he died. He gave me permission to use his card, and I'd always use that account. And so when I moved, I just kept using the account. So, I think that in the grand scheme of things, they're pretty small charges, and I don't know that anybody really wants to expend a lot of energy pursuing those.
Yep. Now, Leanne, we all know Leanne. Hello, Leanne is the admin of the Doomsday Justice for JJ Tylee Facebook group. Link is in the description if you'd like to join. She wants to know if you can explain Zulema's use immunity. What does that actually mean?
So that's a good question, because there's a lot of people who think if you get immunity, you get a get out of jail free card for the rest of your life. And that's really not what happens.
Good.
What happens in this situation? Yeah, she's got a lot to account for. What happens in an immunity agreement is, as a lawyer, you go to the law enforcement and you say, hey, I think my client has some information that is relevant to this particular case that you're interested in. But my client is concerned that they might get prosecuted, so they're only going to give out that information if you promise not to prosecute them. A perfect example is my client gets popped for drug possession and low-level sales. And my client says, look, if you go easy on me and my charges, I'll give up the big guy dealer. And so my client and I go to the police say yes, they draw up a contract that says we won't prosecute you for the current charges that we could charge you for possession and low-level dealing, in return for you giving up the big guy dealer. And generally, it's also couched in terms of the information has to have some value. So it's not just enough to give somebody a name. It has to result in an arrest or in getting the big guy dealer. So there's usually some stipulations and some strings attached to it. And then at the end of the day, that person then isn't prosecuted for that particular crime. But it's not a nobody ever gets to prosecute you for anything agreement. And it's possible that there could be charges within this case that she could still be charged with, that she would not have immunity for.
That's very interesting. I'm curious to see what she has to say, because she, in my mind, she knows a lot about a lot of people and how it all fits together. So I'm very curious.
I think that's true. I think she's definitely in the know.
Yep. Jess Nelson asks, can anything come from Lori's past child custody cases come into this trial?
Yes, to the extent that it is relevant and has some basis, it tells us something about the current charges. So yes, from the standpoint of A lot of people have drawn a lot of conclusions out of some of the psychological evaluations that were involved in those, particularly the ones with Joe Ryan. The other question is, how current is it? How relevant is it to the current circumstances? Because a lot of that information is pretty old. I think there may be some tangentially related information in Charles Vallow's custody dispute with his former wife for his and Lori's stepkids. I don't know how much of that's going to be super relevant to what's going on, but it could be.
Beth Gaither wants to know, if Tammy's autopsy comes back as foul play, you said that there would be a separate filing trial. When do you think that will occur?
Hi, Beth. Beth and I email every once in a while. So, well, that's tough to say. I think, tactically, I think that that Rob Wood is gonna drop them all at the same time. I think that's what makes the most sense for him, is to file them all at the same time. From a public managing the press and all those things, it seems to me like that makes the most sense. So I think he's just waiting for the opportunity to do them all at the same time.
Yeah. Carrie Ann asks, do you think JJ was asleep when Alex brought him back to Lori's the night of the podcast? I have a hard time thinking that he was over playing at Alex's when it was not furnished.
My impression is that Alex took care of the children a lot. And he was pretty hands-on with them. And I suspect JJ was asleep. I don't know. We don't have any way of knowing one way or the other, but if I was going to commit that kind of a crime, I'm not sure I'd do it in front of witnesses. And she had house guests. So I kind of expect that it happened later when there were less eyes on her.
Yeah. My biggest issue with that is all the people involved that we would be able to ask what happened are not real best friends with the truth. So how would we ever know that?
Oh, that's the truth. But that's every case.
That is true.
That's every criminal case. Ferreting out what the truth and what really happened is often a function of, really going through the physical evidence and trying to corroborate what people say with the hands-on evidence.
Jess Nelson would like to know would we know if there were any search warrants for, say, Melanie Gibbs' cell phone records?
Unless the court sealed those search warrants, yeah, we would have the chance to see them, sure. I suspect that they have tracked back every electronic connection. So I would expect that her cell phone records were, there was a search warrant for them.
Now, Carrie Ann asks, and this is an interesting question because I'm surprised we haven't seen this happen yet. Can they come back later and try to separate the cases after it's combined into one trial?
Oh, absolutely. Absolutely. It's the interesting thing about joinder versus severance. Joinder, which is what they did, is done for convenience, for court convenience, for judicial economy, they call it, for everybody, for the same witnesses having to be called for both parties, all of those things, that it's for convenience. Severance is for protecting the constitutional rights of the parties. So absolutely, they could come back and say, we need to sever this trial. That often happens when one's going to turn on the other, or evidence in one trial that's going to come in isn't going to come in the other. One of the reasons I thought that Mark Means would probably sever Lori out of the current charges, the concealing charges, is because Chad is he's charged with the actual act of concealing or altering or destroying evidence, as well as 2 counts of conspiring to do that. Lori is only charged with the conspiracy charges. It would be easy to prove Lori's conspiracy without having to introduce the condition of the bodies and all of those other things. The actual yucky stuff wouldn't have to go in front of a jury. And that kind of stuff can be very inflammatory and can change people's minds about a person's guilt or innocence, even if they're not really related, even if they're not really related to the crime. So the condition of Tylee's body isn't really, it's awful, but it's not legally relevant to whether or not Lori conspired, because the definition of conspiracy is something different. So conspiracy could be proved with nothing but phone records or text messages, where the actual concealing or destroying of the evidence, which is the children's bodies, is going to require that they introduce some of that gnarly information. So from the beginning, I thought Mark Means would be smart to file a motion to sever those charges.
Yep. Now, that kind of ties into our next question, because I think there might be something going on here. Can you explain why you think Mark Means filed this motion to refer to Lori as Mrs. Daybell?
Oh, I don't think there's anything more in that than just that she wants to be called Mrs. Daybell.
Yeah.
I don't think there's anything tactical. I don't think there's anything that sort of telegraphs they're trying to distance themselves from one another or trying to make one another closer. I think it's important to understand. Now, I want to be clear. I am not a member of the LDS Church. This case has made me do a lot of research about LDS doctrine, but I am not an expert. But it's my understanding that LDS doctrine, they believe that in order for a woman to get to the celestial kingdom, they have to be married to a man who is exalted. And that's how they get to heaven. There is not a path for a woman who is not married to make her way into heaven. So that being said, I think that Lori wants everyone to understand that she is married to this person who she still believes is a prophet and who she still believes is going to get her to heaven. And I think it's as simple as that. I
think that's a really good point.
That she's Mrs. Daybell and that Mr. Daybell is a prophet and exalted, and they're all going to heaven in a little rowboat, you know.
I think they'll be making a pit stop, but that's just me.
Yeah.
Leanne asks, do you think that Melanie Pulowski could be charged for anything in Brandon's shooting or anything else in the kids' case? But first, I want to say thank you to Anna, Lily's mom, for the super chat. Thank you so much for being here. I appreciate the support. So, sorry, back to the question.
Thank you. You know, I think that it's a little early. We have not seen charges surrounding that attempt on Brandon. Now, I will say this about Arizona. I moved to Arizona a couple of years ago, so I've been, although I'm retired, I'm a member of the Arizona Bar, but I'm inactive. But I have watched with interest the way that Arizona prosecutes cases. And I just consistently, you see a case on the news and you see something and you think, wow, that's a pretty clear-cut case of charges should come right away. And then you hear 6 months, 8 months later, somebody's finally indicted. So Arizona tends to be really slow on indictments. And I've just noticed that over the last couple of years. So I don't know. It's hard to say. It could just be they're sort of hanging back and waiting to see what happens with the other cases. It could be that Arizona's just said there's not enough to really prosecute anyone. And Melanie Pawlowski has sort of flown under the radar. It's very difficult for me to from what I've seen in the media to judge whether or not how much involvement she's got.
Yeah, she's an interesting character.
Yeah.
And it could be that they simply don't know who shot at Brandon. But to me, couldn't you find the casing? Wouldn't the bullet be lodged in the car? Can you not match it against some of the weapons that may be known? But maybe they just don't know yet.
Yeah. Yeah. Well, I think there's just a lot of information that we're not privy to. They may be, but we're not.
Yeah. Can the family come back on Arizona for wrongful death? Asked Carrie Ann.
Well, not for wrongful death. The only person who could be sued for wrongful death would be Alex. But I think the family potentially could come back and bring some sort of suit against the state of Arizona for not fully investigating Charles's death. I certainly think that they should have fully investigated Charles' death. I don't know, because Alex died so quickly after Charles, that I don't know if it really would have made a difference. As we know that there was a probate case opened by Zulema in Arizona for Alex, but we have no idea whether Alex's estate even has any assets.
Right.
And there's always that question of, do you really bother to go after somebody for something when there's nothing there? So potentially they could go after Alex's estate for wrongful death, and potentially could go after the police department for not fully investigating Charles's death.
Stephanie Ceresi asked, do we know whether fingerprints were on the duct tape binding the bodies? But I have 2 super chats to thank real quick. I'm really sorry. Scroll down and say hi. I'm sorry for people with the super chats. I try to get them right away, but I don't want to interrupt Lori. So thank you again, Anna, Lily's mom, and Miss Sophia. Thank you both so much. I appreciate it. So let's hear what Lori has to say about that question, which I actually just forgot. All right. Do we know if their fingerprints were on the duct tape binding the bodies?
We don't, because we have not seen autopsy reports or any of the other, any of the forensic reports. So we don't know. I think I would say from my experience, duct tape is one of those things that it's very hard to handle without leaving fingerprints on. The other thing about duct tape, and it's kind of odd to say, but it's very difficult to wear rubber gloves with duct tape because it sticks to everything, and it's hard to handle. So people are less likely to wear rubber gloves when they're handling duct tape because you end up with your gloves stuck to everything. And it definitely is a surface that is prone to leave fingerprints. So I would expect that there would be some evidence and some trace evidence because, again, it's sticky, it picks up everything. But I don't know for sure because we haven't seen those reports.
Yeah, hopefully that'll be forthcoming soon. Stephanie also asks, have you seen Murder Among the Mormons on Netflix? If so, do you see any parallels? I do. It seems narcissistic liars end up thinking they can alter and create their own reality.
Well, I think in the grand scheme of things, I haven't seen the whole series. I watched one episode of it. I'm familiar with the case. I read The White Salamander a gazillion years ago when the case first happened. And it's an interesting case. For those of you that don't know, this was a guy who was purported to be a collector of rare LDS documents. And it turned out that he was forging them. And they were documents that were not particularly, I won't say, they were documents that brought into question the origins of the church, the origins of Joseph Smith and how he created the church. And so there were documents that the church really didn't want out disseminated to the public. So he realized that if he created those kind of documents, then the church would buy them to keep them under wraps. And, you know, I don't know if a particular faith lends itself to dishonesty or any more than another. You know, I think people are human, and in his case, he saw that was he had a real clear money motive for it. He saw that it was a lucrative endeavor, and then when he discovered that he thought he was going to get caught, he started setting bombs and blowing people up.
That escalated quickly.
It did, yeah. I don't know if I see the parallels with that. I certainly think that people who believe they're above the law, people who have perhaps some sociopath kind of tendencies and believe that the law doesn't apply to them, are likely to commit crimes. And they are also the sorts of people who are sometimes caught up in a belief system that says you're better, more important than anybody else, and you have more right to be above the law. So I think maybe those parallels, but I'm not sure there's a lot of parallels to the two cases.
Right. I think there's a big difference between the religion itself and these actions, because we see these actions in all religions and walks of life. So I don't think the Mormon faith is more prone to it. No, maybe some things, but not, something like that. But that's going to come up in this trial in a big way, I'm sure, and we'll have lots of debates about it.
I mean, I have to say, I live in Mesa, Arizona, and Mesa, Arizona is one of the areas where, if you know a little bit about LDS history, when Utah wanted to become a state, and the federal government said you can't do that if you're allowing polygamy, and Utah decided to outlaw polygamy, a lot of the families who had been living in Utah moved to Arizona because Arizona was not yet a state, and in fact, Arizona was the last of the 48 contiguous states to become a state. So there's a very large LDS population, particularly here. I mean, there is a white-spired church ward on just about every corner in Mesa, Arizona. And I will tell you that it makes for a lovely community, and they're lovely neighbors. And I don't ascribe to the LDS doctrine, but I can't badmouth the mainstream church.
Right.
I think that where we get into difficulty, I think where the church gets into difficulty is that a lot of mainstream Christian churches really take the position that their doctrine is set by biblical writings that are 2,000 years old and that are not subject to change. And the church has always had a more open attitude about personal revelations and about their prophet being able to alter the doctrine of the church based on his own revelations. So over time, the rules and sort of the doctrine of the church has changed. And when you suggest to people that the doctrine is somehow malleable, I think it leads people to, if they disagree, to create offshoots. And that's how many of the splinter groups of the LDS church got started. And they're certainly not groups that the mainstream church in any way condones.
Right. Green Eggs and Ham asked something we touched on earlier. Can testimony from the preliminary hearing be used to reaffirm statements made during the upcoming trials? And I would say yes, because once it's on the record, it's on the record.
Absolutely. Yeah. And lawyers like that because they've got a transcript of what the person said under oath last time. And now that makes it real easy to impeach somebody if their story changes. Yeah.
Oh, excuse me, I'm trying really hard not to sneeze. I'm having some allergies myself.
It's bad.
Don't sneeze. Oh, goodness. Let's see. One thing, just to point out for chat, we're not really here to debate the merits or downfalls of the LDS faith. That's something
Yes.
you know from watching me. I don't like to see in chat. So if we could cut that out, that'd be great.
Yes.
Let's see. I'm skipping past all the Mormon questions. Let's see. Linda asks, what I don't
down that road, but
Linda says, what I don't get is Chad texted Tammy about killing a raccoon. Others think it was the kids, but I thought Tammy passed before the kids went missing.
No.
Nope.
No, the kids were missing early September for Tylee, a little bit later in September for JJ, and then Tammy didn't die until October. So, yeah, she was still alive, and that's one of the things that a lot of people are curious about. Where was Tammy when they were burying JJ in the backyard and burning Tylee's remains? So, yeah.
Yes, sorry. Just another comment just kind of shook me. We're not going to discuss cannibalism, so we're moving past that. Southeastern Idaho has more LDS per capita than Utah, so it's worse there. Is a statement from you. Southeastern Idaho has more LDS per capita than Utah, so it's worse there. Okay.
I don't know those statistics, but I do know that within Rexburg, about 96% of the population in Rexburg are members of the LDS Church. Yeah. And I think that could cut both ways for both sides, frankly. I mean, on one side, I think the folks who are members of the church are very unhappy with the way that the church has been portrayed, thanks to Lori and Chad. And so that could prejudice them against Lori and Chad during the trial as much as, as serving as something that could be positive because they're church members.
I think what might be interesting for the defense in this case is you have Lori and Chad and their belief system clearly not being LDS doctrine, but then you have their best friends like Melanie and David on the stand saying, of course we're LDS. That's such a dichotomy. And
right.
What is a jury going to make of that? Imagine it's an LDS heavy jury hearing half of them, the witnesses, say, yes, of course we're good LDS people, and then seeing Lori and Chad's beliefs that are clearly not. Could that create some maybe cognitive dissonance for the jury?
Oh, absolutely. I think that it's certainly a confusion. Thank you, Sassy Cat, for just telling me I look better in person than in my pic. I've been trying not to read the comments because they're kind of distracting, but thank you for that.
Now, while we're waiting for more questions to come up, and guys, if you have a question, just put it in chat. I'm keeping a close eye on it. I have a question for you as a defense attorney. This is something I've wrestled with for years. And since I've got you here captive, I used to have the opinion that defense attorneys, how could you defend somebody like that? What's wrong with you? Where are your morals? Until I encountered Kirk Nurmi. And I read his book, had some conversations, and it totally changed my mind and made me see the importance and the necessity of defense attorneys. But in general, you take some flack for that. How do you deal with that?
Oh, how do I deal with it?
Or how does anybody? Because I'm feeling it too.
I always tell people that, you're not a lawyer for 27 years without developing skin like an elephant. So I have pretty thick skin. So that's how I deal with it, part of it. But the truth is that our system is so special and so weighted toward individual rights. Our system, we're the freest people in the world, and our individual rights are protected by the very laws that protect people that other people think, oh, how could you represent that guy because they're guilty? Because if we don't protect everyone's rights, then we don't protect yours when you get arrested, right? Or whether you're innocent or guilty.
Right.
In order to do the greater good, we have to protect everybody's individual rights. So as a defense attorney, my first job is to make sure that there is a check on the power of the state. So ultimately, the DA has virtually unlimited resources. They can send 100 police officers out to walk elbow to elbow and canvass yards and acres of property if that's the way they want to use their resources. They have resources that the average person doesn't have. And in order to, and they also have immense discretion in how they prosecute criminal cases. So in order to have a check on that, you have to have defense attorneys that are willing to stand up and say, wait a minute, you've overstepped your power. You're abusing your power. And to protect against those abuses of power, we have to make sure that they do their job so we can do ours. So, sometimes it's as simple as making sure that the charges actually match the facts and that they're not inflating the charges and charging something that's not really supported by the facts. And then just the question of, was your home illegally searched? Did they have a valid warrant? Did they disregard a request for you to have a lawyer present? Did they, it's a matter of, if you don't check those things, then they disappear. So that part's important. I also say, I think it's really important for people to have somebody say, okay, just because you did this bad thing, you're not necessarily a bad person. Let's see what we can do to get you back on the right track, hold you accountable for the wrong thing that you did. But let's see if there's some way that we can move you past that. So I have a wonderful example. A woman who I worked with, who when I met her was addicted to methamphetamine, was working as an exotic dancer at the local men's club, was hanging out with a lot of really bad people, and who was really making some poor choices. And she showed up at the local gas station mini mart with a couple of guys who she knew and acted as the lookout and the getaway driver when they went in and did an armed robbery at the mini mart. And when I first met her, she was in jail and she was furious, detoxing, not a friendly face, and just kept saying to me, I can't go to prison. I can't go to prison. And I kept saying, you don't understand. This is a mandatory sentence. Armed robbery is like a mandatory prison sentence. We were finally able to get a deal where her charges got moved out of the mandatory sentencing grid, and she was able to get good time and get eligibility to be involved in programs and all of those things, but it still meant a prison term.
Right.
And she and I had this amazing conversation about what you do with the next 3 years is up to you. You can waste it in prison or you can do something constructive. And bless her heart, she took it to heart. She did about not quite 2 years, got lots of time off for good time and for participating in drug and alcohol treatment, in retraining. She got her GED and got out of prison, did transitional housing, went to school, got a AA in business and accounting. And when she discovered that because she had a felony on her record, she was going to have trouble finding a job, she started her own business.
Oh, there you go.
It's been almost 8 years, and she has just recently started a nonprofit organization to help other women who are transitioning out of prison.
Excellent.
So,
A good redemption story.
yeah, I
Yeah.
mean, that's why I'm a defense attorney.
Mm-hmm.
So,
Yeah, that's excellent. Back to the case.
yeah.
Margaret Maddox asks, what are your thoughts about the LDS letter to the bishops advising they speak to church council first? Oh, that one threw me. I was upset.
Well, sorry, we're all our citrus trees are blooming here, and allergies are everybody's struggling with them. Yeah, I don't think it was a coincidence. I don't think that was just just periodically we send these kind of letters out to our people. I don't think that was it at all. But I do think that it had something to do with this case. I also think that it had something to do with Brandon Boudreaux and all of the terrible things that were being said about him in Arizona. And so, yeah, I think, and it was concerning, and Mark Means had every reason to be upset about the impact that it could have on a jury pool.
Definitely. It's just Robbie asked, could I ask Lori Hellis do you foresee this continuing to go on in breakout sessions because of the evidence, etc.? If that is, so will we not hear more evidence till trial?
So when I looked at the latest hearing notice, you'll notice that the subject matter has been redacted out of that. That makes me suspicious we're going to see breakout sessions in that hearing. I don't think we're going to continue to see those if we are going to have hearings on a motion to dismiss or hearings on a motion to change venue. I think we might see them agree to change venue because I don't think anybody thinks that Rexburg's
Right.
a good place to have that. So it wouldn't surprise me to have them stipulate to that. But if they do have a hearing, I think that one will be broadcast. I think that the judge will be trying to limit those private breakout sessions to information that's really sensitive and could impact the jury pool.
Definitely. Judge Boyce seems very fair, but very cognizant of the fact that there is immense public interest in this case and the public has a right to know. I think he's balanced that really well so far.
Yeah, I think so too. I think that he's been really patient and fair with everybody. And so I haven't seen anything in his demeanor or in his rulings that would make me think, what's going on?
Mm-hmm. Stephanie Ceresi says that we're great together and we'll work together someday when I pass the bar. But you're retired. That'll be challenging. We'll figure it out.
Well, you never know. Retirement isn't always permanent.
That is true. That is true.
For now, I'm inactive in both parts.
Jess wants to know if you think when charges come for Tammy's death, would that be all one trial with the kids, or do you think that would be separate? I think we touched on that earlier.
Yeah, no, I definitely would be separate. Yeah, because there's certainly information and evidence that would come in one that wouldn't be relevant to the other. Yeah, and they're two, when we think about charging things together or separately, we usually think about them as, are they separate events? And in that case, they certainly are separate events.
Okay, and Leanne asks, do you think that Chad increasing Tammy's life insurance 3 days before she met her demise is going to have any bearing on her case if there is no proof of foul play?
Well, I think that all goes to circumstantial evidence. So somewhere along the line, and it may have been thanks to Perry Mason, people started believing that circumstantial evidence wasn't good evidence. And circumstantial evidence is just, we know this fact and we know this fact. So if we know two facts that are related, can we infer an occurrence? And that's circumstantial evidence. And circumstantial evidence is absolutely valid, good evidence in a trial. And we ask jurors every day to make inferences from circumstances. So the fact that they increased Tammy's life insurance a few days before she died, certainly that's part of the circumstantial evidence. Yeah.
Yeah. And Stephanie has a good question. This is someone we don't talk about often enough, I think. Why wasn't Ian Pawlowski called when he spied on the cult activities for the FBI?
How wasn't he called as a witness, you mean?
I'm not sure. I would assume, called maybe as a witness. I believe he is on the witness list, and he's probably had his deposition or stuff. But
yeah,
I mean, his activity for the FBI would be relevant to this case, I would assume.
right. Oh, it's just Robbie. I love your comment about RBG. And she did stay right till the end. And I'm pretty sure that she was on her deathbed really mad that she was not going to hang in there until January.
Yep.
And RBG was the keynote speaker at my law school graduation. So she's my spirit animal. So, yeah. What were we were talking about?
Let's see. Well, the next question. Do you think Arizona police should have pulled Tylee away from her mother after Charles was shot? I'm assuming they're talking about that police interview in Chandler. Or maybe the day they arrived when Charles was shot, and they questioned Lori and Tylee standing there right together.
I think police officers are often hesitant to do that when a mother and a child are standing or are being interviewed together. I think it would have depended on the individual officer and sort of the vibe of what was going on there. But to be honest, I don't think they were suspicious enough. I mean, I think they took what Alex and Lori said at face value, and I don't think they were suspicious enough.
Definitely. Yeah. I think if we were to talk about Charles's death, we have a laundry list of things that were overlooked or downplayed, and that's something that still really fires me up. So maybe one day we'll have to do an entire conversation just on what happened with Charles's case, because it's a very long, years-long epic story of failures all around.
Yeah, absolutely.
Yeah, but that would not, there's no way that they could tie Charles's death to this case because that was in another state, correct?
Well, correct. But I think sort of roundabout, I really think that they're going to use the charges in a conspiracy to commit murder case as leverage to get Lori to plead in the other state, in Idaho.
I'd like to see that. I really would.
Yeah.
Because I know we focus on Tylee and JJ the most, but Charles, Joseph, Tammy, maybe even Alex, we have no idea what happened to him.
Right.
Well, we have an idea of what they say happened to him. Not many of us believe it. But I think there's a lot of deaths. And, it does look very suspicious on its surface to have 6 people dead around Lori Vallow.
Oh, absolutely.
That cannot be a coincidence,
Yeah, I don't think so.
So hopefully this will snowball and we'll get better looks at all of those cases. Now, one question that I've been asked that is not in chat, but I've been asked it repeatedly lately. Can the Woodcocks file a wrongful death suit against Lori and Chad for JJ as his grandparents?
Oh, sure. The question is, what value would that have? If you remember in the OJ case, when OJ was found not guilty, Nicole's parents filed a wrongful death suit against OJ. And the difference is the standard of proof is different. You don't have to prove a wrongful death suit beyond a reasonable doubt. It's only a preponderance of the evidence. So it's a much lower legal standard. And they were able to get a judgment against OJ. So they got a money judgment against OJ, and they collected a lot of money, and they essentially bankrupted him, which was their purpose, was to say, yeah, you're not going to go out and live high on the hog when Nicole's dead. Right. And they were able to do that because he had money. But, we know Tammy and Chad have nothing. So they could file a wrongful death suit, but it's a civil suit, and the remedy is money. And nobody's got anything. So, what's the point?
Yeah. It's just Robbie asks, how much evidence would Kay and Larry be aware of? Are all the details that are being concealed at this point be available to the family under a silent order of some kind?
Well, usually the DA has a victim's advocate, or a person who is the liaison to the victims and the families. And Rob would be in charge of I'll tell what that victim's advocate is allowed to tell them. I would expect that they have seen the autopsies. I would expect that they know the contents of the autopsies. And I would expect that the liaison will be telling them anytime there's any movement on the case. So, we're going to file this, or we're going to file that. So they're explaining those things to them as they go. I don't know that they're going to be privy to all of the evidence. I do know, because I've talked to Kay, that at one point when the preliminary hearing was scheduled, and Larry and Kay clearly were going to be there, then the DA's office did go over the evidence with them ahead of time, so that they weren't hearing that information about how JJ's body was found for the first time in the courtroom.
Yeah,
that was shatteringly difficult testimony for them to hear, even though they already knew it.
Yeah. Brennan Tube asks, have the kids' autopsies been completed and Rob Wood has the reports now?
I've heard varying reports about that. I've heard yes, I've heard no. I would be surprised. I know that Tylee's autopsy was going to take a long time. The FBI's crime lab is very exacting, but they're also very busy and very backed up. But I would be kind of surprised if it hadn't come back just recently.
Yeah, it must be really hard for the family, because they would be made aware of a lot of things that they can't talk about, you know. And I know Kresha has been here in our chat and she's interacted, and her and I have had conversations. And there's things that she can't say to me because she knows I'm a YouTuber. You know what I mean? But there's some things that we have talked about that I can't share. And so this burden of having knowledge that we cannot share is really hard. But all I can say is that once the kids' autopsies are in and released and ready to go, we're going to talk about it. We just have to kind of hold our breath and wait for that moment, because we don't want to leak information, or even the family, they don't want to leak information that could impact the ongoing investigation, because then we could be in real trouble and see Lori and Chad walk, and none of us want that.
Right. Well, I think it's important to remember that by keeping those details confidential, that really is a way of honoring those kids, because keeping that information confidential means that at some point justice is going to be served, and the children they're going to receive the justice that they deserve. So, let's remember that although it's frustrating for the public that we don't know everything right now, because we're none of us patient, and I'm the worst. But we got to remember that we need to honor the children by understanding that the process has to work, and they need to have their day in court and receive justice.
Yeah, we have to trust that process, it's hard sometimes, but I trust our justice system. I think Rob Wood is on it. I don't think he's going to slack and let them off easy. I really don't. I think he would even be hesitant for a plea deal right now, because he's like, you know.
Right.
And I think it'll all be okay. It's just going to take a long time. One thing we talked about the other night was, in most cases, we are not privy to all of this stuff. We hear about somebody getting arrested, and we hear about their trial 4 years later. We do not watch these day-to-day motions and filings and on and on. And so a lot of people are very frustrated with this, because why is this taking so long? But we fail to remember we don't normally see this process. So on one hand, we're very privileged to be able to do this and to talk about every single filing as it happens and see the process. But at the other hand, it's making us realize just how long justice can take sometimes.
Oh, absolutely. It's absolutely true. We don't, we're programmed by television for everything to be beginning, middle, and wrapped up in an hour. And the process just doesn't happen that way. So yeah, I mean, if murder charges come, it could be easily 2 years before we see a trial.
Mm-hmm. Yeah, and 2 more years of these filings back and forth. Won't that be fun?
I did see a question in chat about, I had said, I think the ex parte motions, I had said, I think Rob Wood filed them, and somebody said, yeah, but somebody on another channel said it was the defense. And, you know, I'm reading the tea leaves just like everybody else is. There's no way to know because the judge ordered those filings sealed. So I can only just, you know, jump to, I can conclude from what I know about how filings are done and the process works. But I know that there are other people out there who've said, oh no, the defense filed them. I don't think that's accurate. I think it was Rob Wood that filed them.
This is a big debate, and it's raging all over YouTube. I did make a video earlier today addressing this very fact, and the point is, we don't know. I personally tried to confirm with the court who made that filings, and they're like, ha, that's sealed, go away. They would not tell me. So none of us know who made the filings. We're just going to have to wait and see, and we may not ever see the filing, but we'll be able to see what happens as a result of it, and that will tell us more about who filed it. But for now, nobody knows.
Yeah. Right.
Which is frustrating. If we just knew who filed them, it would make more sense.
Yeah, it is. But that was the choice of the judge. And the judge had the choice to, you know, to allow people to know who filed it, or, you know, I mean, he chose to seal the documents. So we don't know who filed it. We don't know the subject of the filings. We don't know anything about them.
Yep. April Passy. Hi, April. How are you? She wants to know, will the public see the hearing, the status conference that's set for April 7th?
Well, yes. The notice that went out clearly says that it will be broadcast. However, it also blacked out the subject of the conference. So if the subject of the conference is to deal with the issues that were that occurred during the sealed conference, then I suspect that they'll go back into a breakout session to deal with them.
Yeah, I'm expecting it to be kind of like last time. We'll all get together. We'll watch it. We'll be excited. They'll say hi, disappear. We'll talk for half an hour. They'll come back and say bye.
Right. Yeah.
Yep. It's just Robbie wants to know the big question. Why was John Pryor smirking? It's just Robbie likes to twist that knife in my back a little bit. He had gas. I'm telling you, it was just gas. That's all.
I mean, it could be something as simple as somebody said something funny just before they went back out live. It's just impossible to know. I mean, remember that even though these lawyers are on opposite sides, they're collegial, and it could be somebody cracked a joke just before they went back live. I don't know.
Maybe Mark Means showed him the meme that I made of them two in the stagecoach driving down the street.
Yeah.
He thought it was funny. You never know.
Absolutely.
There's a question coming up in chat. That's something that you had a whole newsletter about, which I thought was fascinating. So first, Joe PA, thank you for the super chat. Let me read that. He says, if it was discovered that witnesses lied during the prelim, what would that mean for the state's case? It could be proved that Melanie and David participated. Wouldn't that cause big problems for the state? Excellent question, Joe.
Participated in...
I would assume he means the murder. Yeah.
Oh, certainly. Certainly, if you have a witness that you can prove has culpability in the crime, yeah, that's big time problem. I want to say, first of all, witnesses lie all the time. It's the job of the finder of fact, whether that's the judge or the jury, to decide who they believe and to measure and to weigh credibility. Because witnesses, you know, yes, they take an oath to tell the truth, and then they get on the stand and they lie through their teeth because they're protecting their own self-interest. I don't know whether David and Melanie were involved or whether or not they lied when they were on the stand, but yes, it could cause a lot of problems for the state's case, if the state's case were based on their testimony, you know, the state's case was really based primarily on the evidence that was presented from law enforcement. So I'm not sure in the current charges that Melanie and David lying in the preliminary would have that much of an impact. But certainly if later you can prove that David and Melanie had some culpability in the deaths of the children, then yeah, that would change the complexion of the case pretty radically.
I do think that Melanie in particular is a problematic witness for the state because her testimony can be impeached so very easily by the defense. And I'm pretty sure Rob Wood's aware of that. So she may be downplayed. She's not going to be the star witness of the case. It's not going to hang on her testimony.
I mean, I wouldn't expect her to be the star witness of the case anyway, because what does she really have to add to murder charges? I mean, the issue that she was really brought into court on in the preliminary hearing was the issue of Lori telling people that JJ was with her when he wasn't. And Lori asking her to lie.
Yeah, that was Melanie Gibbs, Stephanie, we were talking about. And that was the first time we'd heard that she had actually lied to the police at first and then went back and changed her story 10 days later. So that was a very interesting twist that day.
Right.
But the question that had come up in chat before Joe's question about Chad's house, you had a whole newsletter explaining Chad giving the house to Pryor and the complications that could come up if he is charged with her murder.
Oh, yeah. Okay. It's not unusual for people to put up property in lieu of attorney fees. And it's not unusual for lawyers to enter into those agreements. It gets a little dicey if it becomes a situation where the lawyer's now forced to choose their own monetary interests versus their clients. So there can be that conflict of interest. But in general, people are allowed to pledge their house in lieu of their attorney fees. At the time, I have to assume some things. I don't believe that Tammy had a will when she died. So under Idaho law, the house passed to Chad completely upon her death. Then he was free to do with that house whatever he wanted to because it was his sole property. He then pledged it to John Pryor in lieu of his attorney fees. Because he has not been charged with Tammy's death, the Slayer statute, the statute that says you can't benefit from committing a crime, doesn't apply. So it was legal for him to deed that house to John Pryor in lieu of attorney fees.
So if he is charged with her murder, is that going to create problems, or is that a done deal now?
I think it's a done deal.
Okay. I don't know why John Pryor would want that house. I know he wants money, but that just gives me the creeps all over.
Well, it could be it's better than nothing. And
yeah.
My understanding was at some point that Chad's children were living there, and he may be renting it back to Chad's children. But then I heard from somebody in Rexburg that they drove by it and it was empty. So I don't know. I mean, it could be in John Pryor's case just a case of, well, it's better than nothing. And, real estate doesn't necessarily depreciate even when terrible things happen on it.
And Brennan Tube asked along the same line, since Chad and Lori were married prior to their arrests, can Chad use the house to pay for Lori's attorney as well?
Well, he could if he chose to, although she was never on the deed to the property, and so never really had a verifiable interest in it, and their marriage was pretty short-lived before all this happened. So it's possible because Chad could do anything he wanted with this.
Right.
Owns the house.
Seems like John Pryor's going to get the house and Mark Means gets a case of lipstick or something. We don't know.
You know, the gold mine in the shaft, right?
There you go. There you go. All right. So I'm not sure how long you wanted to go tonight. We've been almost an hour and a half.
Yeah.
Are you up for more questions? Are you ready to hang out? Chat is slowing down a little bit. So I think
let's go another 15 minutes or so, and then we'll wrap it up.
Okay, here's a great question from USA Kiwi who asks, was Alex the one with his phone? What if Lori had Alex's phone at Chad's property?
Well, that's an excellent question. I know that there was always a lot of talk about the fact that Lori had many phones. I mean, Tylee used to laugh at her and say she was like a drug dealer because she had so many phones. So anything is possible in this case. I think it's a little unusual. I think that there are a few things that they've been able to corroborate. I know that Alex's phone pinged places, and then they were able to show that he'd used his credit card in those places on that day. Like, I think there was a mini mart or something where he went and used his credit card, which kind of, supports the fact that he was there and it was his phone and it was in his possession. So
right, he went to Del Taco after being
they do those kind of corroborating and cross-matching evidence. So yeah.
And plus, we have no idea about Lori's cell phone pings. They haven't told us that. They have them. Right. So that's going to add another layer to all of this.
Oh, absolutely.
For sure.
Absolutely.
Let's see. Stephanie Markert asks, I was wondering, do you know why the original attorneys for Lori backed out? She's always wondered that.
I've wondered that as well. If you sort of cast your mind back all that time ago, Mark Means came in because he was a family law attorney, and the original charges were the original orders from the court were to produce the children to the court, presumably in sort of like a juvenile matter. But then when the extradition happened, the other two attorneys came in, and I can't even remember their names now. Somebody probably does. From one of the criminal law partnerships there in Rexburg. I don't know if they were, sometimes lawyers are just hired for a discrete issue. So it could be that they were only hired to get her through the extradition and bail hearings. I don't know.
I do know that one of her lawyers, the female with the long brown hair, I cannot remember her name, and I apologize for that. She left the case because she had gotten a promotion to a different attorney position, and she could not handle that case at the same time. That's why that was her statement about why she left the case. I don't know about any of the others. But there was some confusion back then. I was even asked this today about the change in judges, because at one point they ran up with an issue with Judge Edens because he had overseen a previous case with some child issue with Lori. Do you remember exactly what happened about that?
Yeah, I do. Judge Edens, first of all, is a magistrate. And in some states, they still separate out more serious cases from less serious cases and have two different levels of judges. So Judge Edens is a magistrate. So he handles sort of lower level matters than, say, Judge Boyce does, because he's a circuit court judge. One of the things that Judge Edens handled routinely were guardianship and child welfare kinds of cases. So before we knew what was going on with the children, what happens in a child welfare case is if a child is removed from a parent and put into foster care, hopefully they're placed with family, but it's not necessarily doesn't necessarily always happen that way. So I think Larry and Kay were advised to file a guardianship for JJ, to assure that if he were returned home, that he wouldn't go into foster care. He would go into their care as his guardian. So they filed the guardianship action, and Judge Eddins was involved in that case. And even though at that point, JJ was already dead and there was no chance that guardianship was going to continue, there was some discussion about whether or not he could continue to hear the lower level, the preliminary hearing and a bunch of other stuff, because he'd heard that case. But they didn't remove him, so.
All right, here's a good question. This is one of my little pet projects in this case. Why didn't Mark Means get in trouble to lying to the judge early on when he asked Means if he ever represented anyone named in the charges, and he said no. But before that, he himself said on his Twitter that he had represented Chad.
So this is one of those questions that's a little foggy because the decision was made in chambers.
Yep.
And all the documents, the motions, all the briefs and all that were all sealed. So it's a little difficult to tell. My suspicion is that when Mark Means said he was representing both of them, it was prior to Chad being charged with anything. So at that point, there was no real concrete conflict of interest because he wasn't representing co-defendants who could potentially, whose interests could potentially be opposite one another.
Right.
So
I have a little insight into that, and what I have discovered is that at that point, when this happened, no information had come from Chad to Mark Means that would impact his ability to represent Lori at that time. So he hadn't divulged all the secrets, so to speak. So at that point,
right, and the only discovery that Mark Means had was Lori's.
Right.
Yeah. So, conflicts of interest really are based on, do you have information from one person that you could use to the detriment of someone else? So I think that's why he wasn't disqualified.
Right. We have chat is melting down. We have daydreams about Judd Eddins happening. Apparently people miss him. And Jess Nelson wants to know, when it goes to trial, will we get to see all of those cute FBI agents again? This is where we're at right now.
So here's something you need to know about me. I'm a sucker for guys in uniform. I've been married twice. Both of them wore uniforms, okay? My husband's a retired fighter pilot, and I first met him, he was wearing a flight suit. So you got to know that it was a joke when I was practicing that the DA knew that he could really throw my game off if he packed the courtroom with a bunch of really cute.
Oh, no.
So I'm with you, because I thought there were several very attractive law enforcement guys that were there at the preliminary hearing. So
here's hoping. Call all the FBI agents back.
That's right.
All right, goodness. All right, I think it's about time to wrap this up. Guys, thank you so much for your brilliant questions. You had some really great questions tonight. And Lori, people have been, I have been relying on you and your insight into this case for a year now. And so has everyone in chat. And it was so great to have you here. We definitely have to do this again.
Well, it's nice to meet everybody finally, face to face, right?
Yeah, definitely.
But Ewan, I want to thank you for jumping in at the last minute to help this happen, because I am not technologically savvy, and I'm happy to appear and talk because that's what I do best. But I'm when it comes to pushing all the right buttons, I'm clueless. So we really appreciate you for jumping in to help this.
And I will work with you outside of this stream. We'll get you going, get you all set up so you can do this whenever you want to. Okay. But please give a huge thanks to Lori Hellis, and also mods, if you can drop the link to Lori Hellis's website, thelorivallowstory.com, where you can sign up for her newsletter free. It'll come to your email inbox. Whenever something big happens, that's the first thing I go to look for. So, please sign up for that. It's well worth your time.
And I always like to tell people, I answer emails. So if you have a question and you email me with a question that comes up out of one of my newsletters, I answer them all.
Yes, she does. I can attest to that. I'm like, Lord, what does this mean? Help. Oh, definitely. Beth, thank you so much for the
Thanks
super
so much.
chat. Appreciate your support.
Thanks so
Okay,
much. It's great to be part of this community. I've really enjoyed getting to know you all, and keep the emails coming.
we definitely will. So the link to the Facebook group that is sponsoring this will not sponsor, you know what I mean? This is their live stream, not mine. They're in the description below if you want to apply to join that group. It's a fantastic group of people. Lori's there. I'm there. A lot of great people are there. So join that Facebook group. Discord, Lori Hellis is also on Discord. So, you know, we have a lot of access. So thank you all for being here. I'll probably do another live this weekend and talk about other stuff. And just stay tuned. Stay tuned to the Facebook groups, Discord, all that stuff. Lori Hellis is on Twitter. Sign up for the newsletter, yada, yada. We're everywhere. You can't miss us.
Thanks again, Ewan.
Thank you. Good night. And I appreciate everyone being here.
Good night.
I got to find the hang up button. This is my hard part. I never know how to end it.
Okay.
There we go.